What kind of a dispute you are saying is
This is a contractual dispute, Your Lordship.
contractual dispute means what?
Between the the predecessor is a government contractor, Your Lordship.
It would not come within public demand.
No, my lords.
No.
No.
Then you take up the matter in appeal.
My lords, earlier, my lord, the state was required to file a contract with my lords.
Have they filed it?
What's the lords?
मेल पे दे दिए तुमने
Lord,
और भी सब कर
Don't affidavit of respondent 2 and 3 is there.
Lord, they say that they have mailed me, Your Lordship, but thank you. My lords, the predecessor is aggrieved by an issue of 5 of my writ application, my lord, by which the certificate officer has rejected my objection under section 9 of the Bihar and Orissa Public Demand Recovery Act on the sole ground that the objection has been filed beyond the period of 30 days, Your Lordship. And my second submission to Your Lordship is that, my lord, the entire prosecution is non-maintainable on account of fact that the dispute is such that that will not be covered within the Bihar and Orissa Public Demand
File an
Recovery Act.
appeal under section 60.
My lords,
File an appeal
Lords,
against that order.
because I had filed an objection, Your Lordship, the objection has been rejected only on account of fact that it is beyond 30 days
Against
time.
that
Your Lords.
appeal lies under section 60.
My lord, section 16 is
60.
60.
I might be wrong, but no.
60 appeal.
My lord, an appeal from original order.
Yes.
My lord, but my lord, then original order has not yet been passed, Your Lordship.
So at that time only you can take all the arguments.
Lords, what I am submitting is that the entire the proceeding is, my lord, not maintainable because this has, my lord, arisen out of a contractual agreement between, my lord, the petitioner and the state government, Your Lordship. Lord, there was an agreement to complete certain projects work, Your Lordship. The work could not be completed, and thereafter they have said that there is a debt of rupees 67 lakhs on account of my lord, non-completion of the work on the part of the petitioner, my lord. My lord, may kindly come to an issue of one of my writ application, Your Lordship. That is the part of the standard bidding document, my lord, which stipulates that in the event of any dispute, there shall be a committee and the dispute shall be referred to the committee and the decision of the committee shall be final. And there is also a provision of appeal against the, my lord, decision of the committee. My lord, without taking recourse to this standard bidding document, Your Lordship, they say that the work had been allotted to the petitioner. I completed part of the work. The part of the work could not be completed. Therefore, they have suffered a loss. And my lord, they bring a proceeding under the certificate case, Your Lordship. This is not maintainable, my lords. Because, my lord, Schedule 1 to the Act does not, my lord, include any dispute arising out of a contractual, my lord, agreement between two parties, Your Lordship.
So,
Lord, Schedule 1 refers to the disputes which may be brought within the purview of Public Demand Recovery Act, my lord.
Schedule 1. What kind of a dispute you are saying is
This is a contractual dispute, Your Lordship.
contractual dispute means what?
Between the, my lord, the predecessor is a government contractor, Your Lordship, and there was a agreement between the parties, Your Lordship, for completion of certain works, Your Lordship, for construction of roads under the, my lord, Pradhan Mantri Gramin Sadak Yojana. They award contract for 6 works, Your Lordship. 3 has been completed.
It would not come within public demand.
No, my lords.
No.
No.
Then you take up the matter in appeal. That it is not a public demand.
So for that, I had filed an objection under section 9, my lord. And that has been
That
rejected.
has been rejected now.
That has been rejected only on account of fact that it is beyond the stipulated period of 30 days, my lords. And step 5 is the order, Your Lordship.
Anything else?
My lords.
Anything else?
No, my lords.
Likit, the petitioner challenges the PDR proceedings initiated against him under the Bihar and Orissa Public Demands Recovery Act 1914, Learned Counsel submits that the dispute and claim raised by the respondents does not come within the ambit of public demands as mentioned in Schedule 1,
Yes.
as it is a claim under a contract. Learned Counsel further submits that he had filed objections under Section 9, which have been rejected on the ground of limitation
Yes.
by the concerned authority. For contra, Learned Counsel appearing for the state has objected to the maintainability of the writ petition, and it has been stated that the petitioner has an efficacious remedy to take up all the objections while filing appeal against the order. The petitioner, I have considered this submission. Schedule 1 to the Act of 1914 was amended by the Bihar and Orissa Public Demands Recovery Amendment Act 1993, and it lists any areas of revenue which remains due in different circumstances. More pertinently, in terms of clause 9 of schedule, any money payable to a servant of the government or any local authority in respect of which the person liable to pay the same has agreed by a written instrument that it will be recoverable as a public demand. Thus, if an agreement is entered into, namely a contract, and the same is not abided, and the amount payable is not paid to the local authority, government, or any of its bodies, the same is recoverable as a public demand. Thus, demand would be as mentioned in clause in item 3, 4 and 7, which read as under. Collectively, reading the aforesaid provisions, it is apparent that the amount as claimed by the respondents would be recoverable as a public demand, since an agreement has been entered between the parties and the money arises on account of the said contract as admitted by the petitioner himself. Keeping in view thereto, the contention of the learned counsel stands rejected. Para. As regards the petitioner's objection, which have been rejected on the ground of limitation, in the considered opinion of this court, the petitioner can take up the matter again before the concerned authority, giving out reasons for the delay in filing the objections. In the opinion of this court, the time frame laid down for filing of objections is not mandatory but is directory in nature. Recently, the Apex Court in so-and-so case 3 has held such limitations provided under the various acts to be directory in nature. In view thereof, the concerned authority ought to examine the issues on merits instead of delving on limitation issue. Granting such liberty, writ petition is dismissed with the aforesaid observations.